Okay, media chain.
Nyame adom yen so ye papa. And was a good day for more petitioners, me boy.
Oh,
Ekosiisen on
you either have a
Asempa
good day
FM.
or a bad day when the court gives a ruling or a judgment on the case. But so to the extent that, and then yeah, this said, yeah, and the court in the name, and you now find a church as to why need you move it's better course of my quite yeah real case. Apart from that, no, court no, anka dia court let you and
And ruling beba.
so we will know whether today was good or bad, depending on how
Depending on how a ruling. But who kasama petitioner no but uti court na utie counter argument, especially from Council for Second Respondent Akoto Ampao. Any authorities our site any ade to back or more argument no. Na then na ekoso wo trim.
oh the other course will meeting is any kind. Dear Nkwana, the second respondent, in this case, Nanado Dance Kufuad, and then a lawyer for almost soon here.
Ekosiisen on Asempa
Almost
FM.
history was a move for that. Because I come here say they are even crying more than the bereaved. Electoral Commission for now, 75 Jimenez, a 7 year family. Ono kra no nani mmerenti situation said the o manpenye Kufuado na lawyer for say we will be. It do baby kra no the president of the bench Justice Eniyeboa ka say lawyer go talk Jimenza an electoral commission enye wo your client is Nanado obi azon ka say officer usupina o manpenye Kufuado to come and testify in this case. So when you have baby ya o kasa te said ya we lawyer Mensa or the electoral commission exercise. So next is the court no go who say the lawyer for the second respondent you know ya brother nentia ye na ye disane say tie no man penye Kufuwa bisu dey suma si get ye ben na only the Mensa dintia ya se biso Osro se Jimensa beba.
Ekosiisen on Asempa FM.
What is Nanado Dankwa Kufuado scared of? I got to about Jimensa and every officer. I say one wedding. So I in a Juma Kama. Nkunim with wedding. Also wedding. And you know, Chris to do the idea that's the one I do. It's a young go. And then get there would say the man say about that. Now I bet the amount. I'm a real none the court to the who say I'm packed. Name your man be near Kufuad. About why I saw you know, Bijim Kuni, I draw Mahamad here. I had the Okekano, and fuck of Yaman. I didn't say that would true. About why you 2 years. They're not the BSC in Aswa or the shells to my to a banner. Hey, Jimensa. Ono na ye ba no dan ni ma electoral commission abato onu du so anso ono na be body to dwa abato onu du so anso e be ye mra ono na nsa safi abato onu du so anso e be ye mra no ehu da wubo ono na ye bidia mani na ye as far as the presidential election is concerned because
Ekosiisen on Asempa FM.
Na ekinyadia ba na do mahama say when ni kunim abana wo se wo na wo we ne ye no enye no kwesa wo mram pe ono ani declaration no no ani ti obobo abani ye no se wo na wa we ma mi kwa se di odi kan de be tuja no o ye mfonso ono ana ata o mu nyina mo so ma dia tu so o ye mfonso o the correction wasisan de bia figure for ba to man penye Kufuado kra no enti enye ne de think a Jimenez about that can do. Now, inconsistency gets me now. What about the chick? Not Ghana for a man only one to a man. One way well, but one more why we have to know who say, I said, and you said, for chill, and no view. What is candidate of Fufado scared of? And what is Jimenez scared of? Dear no money to see any. Omania bleeding, Sakianic Jimenez. Oh, rather that could be that Emma in that. As I'm with you, more.
Ekosiisen on Asempa FM.
Because you has them within 20 cents that will be Yara wouldn't ever go to that court. So your mind so full. Near did you make the sentence that now what about the producer? Why near the man William Edia favor with you? Naturally, that person would want an opportunity to vindicate herself or to show that they work can act on the credibility, the integrity, the eye intact. Whether you have a case or not, that person naturally can't send to before that person will be chilling.
Yes, I mean, but we are lawyer, you know, sir.
And just say you don't have a petition and one day so. I mean, these are issues that even journalists are asking. They are all saying that answers must be provided. Mema bawu show sure. Obi matter say what these are, people who speak for the second respondent. Some of these questions. So why this declaration and these figures and not these figures? Which of them should we rely on? Obi in this
on
the hearing of
Asempa
this
FM.
Eastern region. You have two declaration forms. Here I'm talking about from 12 for one region. Used to say on the balcony here, we don't even know which one they use and the reasons why they use that instead of the other. Yahoo from 30. My minister. Oh yeah, but for no way you mean and no say you hear Yamma a good so I would not the declaration. And who send the baby back? Why your fast in fact, I dance for baby dance say. A Juma crack and what's away as returning officer by assembling and collating results from 50 regions in the world. When Petition put one net about the collation room only twice, 2 occasions about when you 2 minutes grand of oil. Meanwhile, I'm running or no as returning officer and I wasn't for yes, I am.
But Sammy, all of these, someone provided home, maybe all of these, no more provided home evidence to the court, maybe.
It is not about your providing home.
No, it's a question I me here answer.
Those issues are provided through the cross-examination of witnesses by Jimenez and lawyer.
Absolutely. And they are all evidence before the court as we speak.
No, the fact that they are in evidence doesn't mean that there are no doubts surrounding those issues. There are still doubts surrounding some of those issues. It is only the returning officer who can put those issues.
There are doubts surrounding your evidence,
not our evidence. There are doubts surrounding issues about as a result of cross-examination by lawyer for the electoral commission and lawyer for Nana Danko Kufuado. And I know Nana may cite some of the examples to you.
But the point they say yes, it as legitimate as these issues may be, the respondent the choice to decide say we want to also lead evidence to maybe counter the potency of our evidence before the court. Say let the court decide.
No, it's the okay.
The American say petitioner making the case through the witnesses or my evidence in chief. Ya cross-examine one any BBR petitioner is closing the case. According to the petitioner, he has put a solid, compelling case before the court. Choice whether to also lead evidence to counter the potency of petition and the case and any evidence or the other court name. Elected Darby, lead the evidence be let the court decide on that potent, compelling case a petition and the other. What is your problem?
No, sir, dear, who can come, watch it.
Mhm.
And then the year the court and found baby.
I don't know if I'm bibia.
And found baby because the one that I can say
Mhm.
the respondents have a right to say that you will not call any witness.
Yes. Yes. Yes.
And the electoral commission for war, fine say, and after who did some say, yani, and as I said, number court, the important
Asempa FM.
and no Yapa could piece to ya water, and of course, it will be TISA review application, and then you file it.
My file review, nene. Okay. Okay. Thursday. Okay.
Until the decision is reviewed, that is the decision.
Yes.
If you'll be anywhere waiting there.
Okay.
The Naya court. The say any of the respondents should be compelled to testify. What the court said last week, and on the Apple review, they say the court cannot compel a party
Ekosiisen on
to call a
Asempa
witness
FM.
to adduce evidence to support the case of that party.
Yes.
And that party has a right to elect not to call any witness. And that when they do that at their own risk. Because the court decide the matter on the basis of the evidence of the other party.
Mm-hmm.
And not there until the court that is the law. And then the court can the court.
Mm-hmm.
And then the can was a Mrs. Needham. The Mensa is not a party in this case. I don't know why lawyers who understand this simple issue are
Asempa FM.
deliberately misleading the public this way. It is so painful. Because that is one of the first things I excel in the law school when you are studying company law.
Separate legal personality.
Say, a body corporate, you can't be a company, a body corporate. Body corporate company, it is a person, what is saying,
Mm-hmm.
it is all your body. I want to start company in the court. For company in Exuma, you for the court. For the company in the court. Because company in the Mrebu not to say ipa. And you say, a body corporate has a separate and distinct personality. From that of
Ekosiisen
its
on
shareholders
Asempa
or
FM.
workers. We all know this. It's quite legal learning. The Mensa or your third person of the electoral commission or your Juba or electoral commission or your electoral commission. The electoral commission your money which means UG Mensa. You have to sue electoral commission. Unless the law says UG Mensa as third person because I don't know your money. Your court anytime in this case, there are three parties. The petitioner, John Mahama, the first respondent, which is the
Asempa
electoral commission
FM.
of Ghana, and then the second respondent, which is Nana Adodan Okufuado, who was declared as winner by G Mensa. G Mensa and your party, and your respondent. So, where from this argument says, court in this case, you cannot compel a party to give evidence. Until you cannot compel G Mensa. Is G Mensa a party? Is G Mensa the electoral committee? I mean, why are people doing this? And now somewhere they call court. And you teacher. And now what they want for court? Now we go crow we for our dance for we. How was it now? Now catch the court and say me we ma.
Ekosiisen on Asempa FM.
Bibi let me here. And running my own point say. The court no back. Medium no court because you'll be invoking the inherent jurisdiction of the court. Court ni will to me say, even though I was one that waka was a movie. Court will to me say, oh, bad or not because the court. Medium move, make I think I'm as a movie. But when you wait, let's let them obey my crying. Nama sounds what be a master minimum. Nama ye ABC, the court will find or to me say or mouth up wine. If you are able to justify that there are certain special circumstances, and we see what's the court on the mouth point, court on the mouth point. And that is why today, the president of the bench, my Lord Justice Eniyabua, told Justice Amanuvo say, a settled principle of law that the court has the power to allow a party to work close to the case to reopen the case. Justice Eniyabua said that repeatedly.
Mm-hmm.
It's a very court to work with court to see a year. And you have one phobia, a idea one room,
Yeah, but say for the court to exercise that discretion, no, to allow party B to reopen his or her case, no. It was say yeah, under some circumstances, exceptional circumstances. And
special circumstances.
Respondent ne point they say special circumstances, no, and as meaty akoto power ma mienu.
That is not the only thing they have said. The reason why I am meeting and say justice system adversarial. So it will be madness to compel your opponent or your party to come and testify or build it.
Yes, quoting Ole no JSC.
Compel. Are we seeking the leave of the court to reopen our case so that we can compel our adversary or a party in this case?
No, but that party is your adversary, no?
The question you loaded. I was saying they answer in Abana.
Okay.
So number one, yes. Second respondent, respondent answer more moka. Omo lawyer for no good pass the moka. Yeah, no matter that no yes, because they know that the court in this ruling never says the chairperson of the EC can never be compelled to testify. The court said the EC cannot be compelled to call a witness.
Yes, that is settled, and you'll be out here.
That is settled, and the EC is not
Ekosiisen on Asempa
FM. The EC is a body corporate established by the 1992 Constitution and an Act of Parliament. It is not Mensa, and we all know that in law, and also you're settled. What you cannot do to the EC, you cannot do to Mensa. That's number one. And number two,
Asempa FM.
Oh, but another you are entitled to as of right. It is at the discretion of the court. So when now the question is, in this case, have we been able to demonstrate such special circumstances, for which reason the court should grant our application for leave for us to reopen our case and subpoena Jean Mensah? In our humble opinion, yes, we've been able to do so. The respondents think that is their opinion. Courts may be say but now let me explain to you why, in our opinion, we have done that. And please, I am not prejudicing the matter which will be determined tomorrow. But I'm only explaining to you our opinion as we have argued in court today. At the end of the day, it is the court which will determine whether they are or not. Now, why do we think that, in our opinion, still have special? Yes, sir. I said, you that court. The men and our court can't say. I dance for parties will be a person of Freddie Biano. Oma dance in fun dance at Ambra by 23 January. The men are the Casa by. The children say, it do you see for so no move your case or what the men as dance me. Not our witness statement, you are there to meet and dance here. And the counsel for the petitioner or second respondent can cross-examine better to know about our dance here. Apart from that, also, no. Yet the kind of ability to say no, yet the kind of court, no, say, on my point, I am Mr. Jim Manson is on send be said. So, Mr. Dumunu, no, we are no, my, no, we are no, that, no. Ever must ask them where you can be here. Me, I can intend. I want man no clue who try a day about one thing. The Manson, Uncle Sanu wants them more crying. About that, at the said, yeah, the court of course, the news I'm going to say. Court, Mamma, John Mahama, 5 million FM. Among the reasons, if you say, my court, no, my point, my name is Anderson, money, one of the reasons, me say, that's me for no, the bad that's not the come. And he said, your mama, a lawyer for person who determines the same way. They better not that come, almost to Tom and not doing process and they should be determined. It's in paper here. You lose to a seminal crap to cast all my enemies as answer this. Now you copy so under review. The men are also by you. On one of them wants to say, now what injustice or injury will they suffer if I don't answer this one question, they won't suffer any injury. How case yeah, because a member phone my member that tell you mama or something way now pa or maybe some me ya no. It what can something way it's someone what cannot know what why and ya someone what they want no fafanaka what why you have sworn an oath. That is why it is in affidavit.
Asempa
So you bet
FM.
me be tawo something way during court examination. I say court examination so ya. Who person wo ye adanko dada do intricate. Ye be tawo question during interrogatory stage, case management. Osi obon check cross examination.
Ekosiisen
cross
on
examination.
Asempa
Osi
FM.
me ma. Enti enne ye ka check course no say. Sansem wana jimensa aka no. A conclusive presumption that Jimensa will testify. And that is why lawyer Petition made reference to section 24 and 26 of the evidence decree, which basically talks about the doctrine of estoppel. Say, Emremuno, you can have a right to do something. But say wanamo anawokasa Emma will be negidie say. That will right no exercise.
Asempa FM.
Na nipa ko no to asem no so a ekire untimi na ne wa no emeka say me ba be exercise are right no. So yes, right.
But Sammy, on that argument, there's a court no really on that. First year.
So even though you have the right to say I can elect not to call a witness to testify, you are a stop because per one case of evidence I was giving in your affidavit, you are a stop from doing that because the evidence decree say in your affidavit, it creates a conclusive presumption. And this is part of your ground for review and your file. But another you court to the say because of Sansem witness, now you are better testify. And no and a young supine in the say or maybe a dance here as you dance me. In any case, and then young one and your work side to be say or better testify. Anyone who followed the proceedings and saw this affidavit, even the court, can say they are surprised. Say, lawyer for the respondent say, almost Fred and media. Because all along, I believe the respected justices of the Supreme Court thought that they will call witnesses based on some of these representations. And also, and that lawyer they are making an argument. Oh, we have no basis forming the opinion. Say at all costs they will call Jesus to testify. And to say yes, for most our opinion, they are and they ask them. But lawyer say, look, even if we decided that time one year now close to your case, you better phrase the men's man about the dance Yamajo Mahama. And can to be there. Because
Ekosiisen on Asempa FM.
I file a witness statement. I'm my electoral commission. The electoral committee and you say the dance.
FM.
And the running man who can say, Obi a wadi dance kata ba so ba be di dance ama wo opponent is wo do Mahama oba ko friend say di dance ama. And then ya o say if for so omunya friend bi into witness statements, they are no longer relying on it. Then we can subpoena her. But then we couldn't have subpoena her. It is so clear.
Sammy, where we are, Mami Musa, my question is, my surprise from the Wakayane, the lawyer Chatushi Katan, so Kaya in court, still the reliance on affidavit, first respondent witness, then assigning, because now one of the key arguments a lawyer Chatushi Katan make here. In time I see or imagine say they will not call on their witness. In the ruling of the court they can say that the extension here is that in the petition before us, the first respondent has not put before us any evidence in the form of an affidavit or otherwise. As already stated, learned counsel for the petitioner only referred us to an affidavit deposed to by the chairperson of the first respondent in opposition to an interlocutory application to serve interrogatories. that affidavit is not evidence in this petition to enable us compel the first respondent to mount the witness box to be cross-examined. And it goes on and on and on. But it is clear, sir, affidavit now constantly more referred to, no, it was in relation to an interlocutory application. It is a more refer, sir.
Why do we even call it interlocutory?
Sir, and yet the real case, not case Nankasan started.
That's not the reason. That's not the reason.
Now, tell me,
it is
based on this ruling.
It is an application that has arisen in the hearing of a substantive matter.
Yes.
So the court hears and determines it.
Absolutely.
Disposes of it and then moves on.
Absolutely.
But it is still, it still arose in the course of the petition.
Yes, but it is not an evidence. The ruling is clear, sir. And yet evidence before the court in the matter in issue.
This question you are asking, the point I'm making is that we disagree with that part of the ruling, and that is why we have applied.
And I'm finally review now. Okay.
So that is grounds for the review now. We have explained there. In fact, we even argue that decision was per inferior. Per inferior because it did not take into consideration section 24 and 26 of the evidence decree. Because if it had taken into consideration that section, and Kawube would say, even though they have the right under order 38, whatever, the order
CI 47 is CI 87, yeah.
Yes, they were stopped because section 26 of the evidence decree, once it's all in their affidavit, the mention will be available for cross-examination. They are stopped, and that is a conclusive presumption. That is one of the disagreements.
Okay, and this can review matters now. What even
if you put that disagreement aside, which the court will hear at appropriate time and determine in its wisdom at appropriate time. Yes, what the court said in the ruling now, one can say,
Ekosiisen on
because of the reasons you read out, the Mensa cannot be compelled to testify.
Yes.
The court said the EC cannot be compelled
to call their witness
the Mensa or any witness to testify for them. And that is different from what we are seeking to do.
Okay.
What is a subpoena? A subpoena, a kwanya, and answer a 2 minute class, court to Maho Kwany. Emma, a party in the case before that court. A issue against a public officer, not the chef public officer, they say. As someone called to D, if I were Juma. Now, wouldn't you near me be? So, we be dear dance your quarter. A bad one court to know who assembly no credit. Now, court to Yama and saying, I hear Juma. And which ye shall say, even those are someone ye come, wouldn't your party dispute? Ye shall, the brat. Now, be dear dance your mammy, I'm in front. In this case, the Mensa is not coming to testify for the EC. She is coming to testify for John Mahama.
For John Mahama. And they may ba my next question. Say, ye name said ye watch the say, case be say you cost a court nankasa so moto. To me, third party be or information be a bit my boa court. Say, Omra, na Omra me boa court in arriving at a particular decision. I know. And some more parties, Ninsono, mutimi third party be say Omra. But so Kaya. There was this question, I think Justice Tokono Ebusai said, Mo Fredjin means say Omra in capacity being. And so a lawyer Chachuchika Tebeka say as a hostile witness, as an adversary to Mo. But my point is, Sammy, say Mo put forward a strong case. Why would you need a witness or your adversary? Some of our Kakrano, Munim, say Bebuamu, say Emuamu. Why go through that risk? So, I put it before the court a strong case.
I think the boy and I am why in your court. I am not in your court. A justice in your court. Mensa your milestone for Ghana for the Sian.
Asempa FM.
Because the Juma and Sasa when you're my. But yes, the Juman. We and also I am for so. For the correction back. After correction, all the figures different, ABBA. Or court. the correction crowd or catch a Ghana for say that's the correct thing we should work with, or the not to baby, and all can as a for. Ye be actually in some baby are back. I found a Juma
Ekosiisen on Asempa FM.
Forms you which is which from 13 or see no to your declaration no kwano. I don't see a be from 13 no papa and you know I'm running to what's a cool use. The Juma was all as returning officer. I don't see a be Juma no kwano one yet. Or no lawyer. I can say that they were caught against the dance for say a dance for dance you be my baby at the cost of one you contumpo. Obviously based on the agreements I catch a lawyer for. And you see, the Ghana for you I read you say. I said why you came. Mammy when and in our father the Duma one femna and 1 month mama. Now she has no who yet. No, that's so of my Ghana, no more Brasodia. You ain't seen any of that.
Na se assemna mo de call court no mo anfa assemna nkoto Ghana fo nyina anim same
I'm coming.
Mo asem no mo de call court mo anfa nkoto Ghana fo nyina anim bench ne nka say without the woman testifying muntimi they cannot rule on this particular matter. So
we have
where from
that this petition for in behalf of all Ghanaians. And that's one thing that we should get. John Mahama and son that man a lawyer for
Ekosiisen on Asempa FM.
This nation. Hope you guys.
Mekaipa.
And in that verse, go and look for that speech. Okachire Ghana for you now. One of the reasons in here, one man a lawyer for the assembly of course. And say Mekaiwa, you saw Mekaiwa say there are certain questions about the declaration agreements and yeah, we all need answers to clear those doubts. Okay, that's your mama kind. That is one of the reasons why you the assembly of course. So we are not just in court to fight a case between John Mahama and Silensa or the East. This issue is bigger than that. It is about our constitution. It is about all Ghanaians. Yegina ni adia to me say. Yede emrabe yejuma. Na mrane say Article 63 of the 1982 Constitution yede yejuma ne say. Omampeni a obeji yeso no. I just say yokoto ba. But
Same, if all what you are saying is
declaration, if I can just land on this, the men's acquire declaration. Also, Mampenya Kupuadunya 6,730,413 votes out of total valid votes of 13,434,574. And into a more Mampenya Kupuado, a percentage of 51.59%. Yakoya and yet it's a 1.595 and yet 50.098 based on 274 constituency results. After the I say, maybe 30 months out results. Now, so may declare about it because maybe a mother what 30 months out in Yafaka, Mampeni, Mahama, and Mahua, still on Mampenia Kupa will be more than 50%. And substantially, and see, based on this, may declare about Mampenia Kupa to say on narrative. As a Yakoyan Kuntaya, what is the Chiman South goes? Echo country of Mahama one. On my Penya Kupa do not 49.625. Meaning, say, the Ayamra Funika, that was said on my Penya Kupa do more than 50%. When ya, and here we are, the Mamma and Sawa Rene. Yet, yes, we are back down court. The men are there to make a declaration or young from percentages to crowd the mass 12 candidates. Okay, Kabumwa, we have 100.3%, a clear mathematical impossibility. And next, not the correction we have, or quarter, no, or another figure we have. Then the figures are changing. And you are saying, sir, in this case, it's not a public interest case which demands that the Mensa will come and provide
Sammy, so where we are, I think the decision to go to court and meet former President Mahama in that famous address, Anawoka Hoa seminar, that decision was born out of the fact, sir, himself as the flag bearer of the NDC and most of you as members of the party who believed say Ghana wanted to aba in a certain way and about one was say John Mahama should be the next president of the Republic of Ghana. That was the belief. And no Mufi said Niyomebi Yanko Yintimode Court Supreme Court under Article 64.1, which is a very specific article for election petition adjudication. Enter Namoko Court. and you went to court, sir, after say be prove your case in you know, it will become clear, sir, John Mahama should have been the rightfully declared winner of the election. Nyamia yamadoma frame witnesses we. Sa evidence I will can and there was the figure way about the figure way in bar numbers necessary everything is before the court in evidence now. And some years say Germany we not some year. We should not even be having this conversation. Maminwe. Moye say Germany in a year. We don't need to be having the conversation. Pose ye per se electoral commission boss eba ye compelling ye subpoena no any because once the case is established by the petitioner, respondent in the DM rekakwa babet na box him. If we've gotten to a point respondent in poker say oh member because the case, then it means maybe just maybe munye you've not been able to prove your case on the balance of probability even muntiminye.
Maybe.
Yeah, maybe, yes, of course.
So maybe. It could also be said maybe you prove your case. And send the star Ghana phone in our person munya anu yetu. No who no correct. They want to know whether the EC chairperson who we pay.
No crane say according to mo. No crane say John Mahama na wini about one meboa.
Immediately I start an answer, then you come up with another.
No, sir, I was some guided conversation. No. I'm not guiding your answer. I'm guiding the conversation. Two different things.
Because I just started. The answer I am giving is that what it may be the case on the balance of probability.
Yeah, because a civil case.
Maybe a case, but respondents no.
Ekosiisen on Asempa FM.
No kwebe shisha adaka mu a so betna adaka mu ni mu a ne yasate se yeso tuna no a ebetiada.
Na say omu dwane the end they praise the Lord. Then you are winning. Sammy, omu dwane the end they praise the Lord because the petitioner is winning the case.
Praise the Lord. That is what I am coming to. I am telling you, sir, there are still lingering questions that have not been settled. Obi, are you telling me that the issue about the Eastern Regional Resource Coalition sheet? There's a maneuver. I can't send you about you to the reason why is here one region, two resource sheet from 12. Bako NDC agent sign, Bako NDC agent and sign. The NDC agent non sign. And on the idea. Are you saying that the questions surrounding that issue have been settled? Are you telling me that the questions surrounding the issue of Form 13 have been settled? There are so many questions. Are you, for example, also telling me that the issue about whether or not the Mensa as a returning officer even did her job as a returning officer by assembly results of the 15th region? Because the Ojo called Hong Kong would be the Equesa White, the Mensa lawyer for Cancer Yampa, Peter McMahon, evidence. Are you telling me so all those issues have been settled? No, we think that there are still lingering questions and require answers. And if I go back to you answer, now what my course, who look wants answer me. Now, Martin Trin made the offender justice. Now, one Ghana for now, who say the Mensa, our electoral committee chairperson, or you know, and now when you know, and requires answers they are provided. That has got nothing to do with whether or not we have discharged a certain burden. No.
And answers to some questions, no. Will it materially affect issues before the court? Court now set it down. Answer to that question, court, no. Of course. Without her coming, no.
Hold on. You saw, for example, during court examination, lawyer Kotampa for Petition South, Samrishi. Or the figure, you see, what trend as well as the total value.
Ekosiisen on
97,000 22 something. And you're correct. Now, correct, there was 99,000 something. And on my general mosquito, a day calculation. Or no lawyer put on for figure, a calculation, which has now become part of the evidence. You don't think that the EC chairperson is the one who can settle that issue as to which of those two figures are correct, whether we should work with Akoto-Ampal's figure or whether we should work with what is on the summary sheet that she worked with? She was a returning officer. She did the coalition. She declared the result. And in that state, in fact, you even asked me, Sammy Gyamfi, the most important document in all these issues are the enactment, which is CI 135. And unfortunately, or fortunately, that CI, per its nature, no any figures. So how do we even know the figures the woman enacted? Don't you always ask me that question?
Mm-hmm.
So don't you want the mentor to come and provide answers to that? She has provided about 5 sets of different figures. Are you not, as a journalist, interested in knowing which of these different sets she enacted? So, Obi, it is not about we being self-centered and self-centered. Oh, we are proving a case. No, we are also interested in substantial justice. We are also interested in testing the credibility of public officers. But
there are other platforms. There are other platforms to go
to bear on these issues and help the court achieve justice.
There are other platforms to go to vindicate.
I'm not satisfied that the matter should be concluded until these lingering questions are settled, and I want to provide answers to these lingering questions. Is the EC chairperson?
Sammy, you are in a court of law through Article 64(1), specific election petition. Hold on, Meba. The issue about protecting the integrity of the EC was somewhere accountable. There are other fora you can vindicate those points. In the Supreme Court, through an election petition, the rules of the game are clear. Prove your case. If you prove your case, you don't have to compel the EC to come. The EC will come. If the EC feels you've not proven your case, come again.
We are calling the Mensa as our witness, as part of proving our case. What is wrong with that?
Oh, okay. In the Oba to help you prove your case.
Not to help us.
On
Oba to testify. No. Oba to testify.
Yeah, also say Oba as part of you proving your case.
Of this matter. So what is this issue about Oba the boy? When you subpoena somebody to come and testify, who subpoena is there? Oba the boy. No, who subpoena is because or no, and it say for example, Obi will company. Now, because I know you have a consultant. Now, GR report the work of course will be now the GR report 3 months on. Then maybe what tax is now at some point you had a certain engagement with the Commissioner General of Ghana Revenue Authority. About what court, I'm a court who create what. So GR about lawyers about my case and you tell the court say Ghana Revenue Authority Commissioner General as someone at that court in the payment of taxes by you dealt with him and all that. So you think that as a Commissioner General or known as our taxes in Yemen national no one needs to ask them who been now dance here. What is wrong in seeking leave from the court to reopen your case so that you can subpoena that Commissioner General to come? That Commissioner General can come and say things that M1 will say. But now, the way the court examination will go will help the court to determine the issues in the just way.
Okay.
It doesn't matter what the person's answers will be, whether the person is credible or not.
The court will determine.
Only under cross-examination. You may think that those things are not important. We disagree. We think that it is important for us to get answers to those questions. Now, one the court will not achieve justice. And that until those questions are answered, there will still be doubts, even after this case is determined. And it's important that once we have come to court to declare all those doubts, there is nothing wrong with what we are doing.
With what we are doing now. Anyways.
We are waiting for the court decision on that.
Yeah, me I don't watch now. On a light note, sir, me GR issue be I'm a lawyer Sammy Gyamfi.
And I'm sure that when the nature of the case demands that the Commissioner General of GRA be compelled to come and testify
on
so that justice will be done. Trust your lawyers and
you'll do that.
In the interest of justice.
Why not? Why not? Me da se papa Sammy. Ya be se din komobio. Why? Me da se pa lawyer Sammy Gyamfi and ya ten nka ne Ekosiisen ne ha ya